Mr. Russo, whenever you're ready.
May it please the court. Thank you, Judge. May it please the court, I'm Anthony Russo for State Farm, the appellant. I'll reserve 5 minutes of my time for rebuttal, Judge.
Okay.
Thank you. This is State Farm's appeal from an order that joined it to a fee judgment against its policyholder, Mr. Eric Satterville. In the course of that adjudication, my client was denied due process, and I'd like to explain how that came about. A prior panel of this court in this same lower tribunal action, but a different appeal, wrote an opinion on a motion for review that ordered the trial court to enter a fee judgment against Eric Satterville, and then added the words, quote, and his insurer. That order was issued by the panel at a time when State Farm was neither a party to that appeal nor a party to the action. As such, it was a void order as to State Farm, and we rely on cases here that are cited in our book. It was a mistake, it was a misapprehension, it was gratuitous or accidental in some way.
Well, State Farm wasn't added to a final judgment subsequent thereto, correct?
It was, Your Honor.
It was.
It was, yes. On remand, from that order, Mr. Marcuson's attorneys filed a motion to join State Farm to a final judgment against Eric Satterville pursuant to the non-joinder statute. State Farm was then served and then made a party for purposes of joining it to that judgment.
But that was, Mr. Russo, that was not the first time, and this circles back to your very opening statement that State Farm was denied due process. That was not the first time that the issue was brought to State Farm's attention, because back in 2015, when this first started coming up, when we first started talking about fees, a motion was filed by the plaintiff that expressly asked to include the insurer. And in fact, State Farm sent Mr. Damon to the hearing on October 28, 2015 to represent State Farm at a hearing to make that, to deal with that very issue. So help me out here. Why, given that the non-joinder statute already provides and has been recognized to provide sort of a truncated version of what would ordinarily be due process protections of separate service, separate action, why isn't that enough?
It's not enough, Your Honor, because State Farm was not a party to the action. It was, of course, it was aware of the motion. It appeared Judge Smith, who conducted that hearing, said, I'm not going to reach the issue of joining State Farm. I can decide that later.
Right, but let me ask you, Mr. Russo, she could have, couldn't she? She could have decided that issue. The issue of joining State Farm was put into play, teed up for hearing. The very case of Hollingsworth gets put into motion, and the lawyer at the outset of the hearing says, yeah, we need to join State Farm at this point. She could have passed on it right there. Would there have been a problem with that?
Yes, there would have been, Judge. The non-joinder statute allows the joinder of insurer only at the time that the judgment is being entered against the insurance company. She was not asked to enter a judgment. That was a fee entitlement issue that was before the judge. And so it would have been untimely, and it would have been improper for her to join State Farm at that time. It's not permitted. We filed the timing of the joinder is set out in 627.4136, and it specifically says at the time that it establishes 3 rules. And a liability insurer may be joined as a party defendant for purposes of entering a final judgment. She did not have a final judgment before her. She did not enter a final judgment. She could not have joined State Farm at that time. Does that answer the question, Your Honor?
Well, I hear your position on it, yes.
Okay. When we were returned by when the case was returned by mandate to the trial court, Judge Durden presiding, Mr. Marcuson's counsel filed the motion to join State Farm. Then State Farm became a party to the lower tribunal action pursuant to the non-joinder statute for purposes of entering a final judgment. By then, the amounts had been decided or settled and ordered by Judge Smith.
Let me pause you on that, because that was another point that got me scratching my head and candidly a little bit concerned. There's a stipulation that gets executed as to the amount of fees, correct?
I believe there was, yes, sir.
It's $700,000.
Right.
Right, and that stipulation gets entered well after the State Farm's position that it's asserting now begins to bubble up, which is that, hey, we weren't a party, we shouldn't be joined to this, correct?
Yes.
Okay. The only signatories to that stipulation were plaintiff's counsel and Mr. Wood, the counsel that is hired by State Farm to represent, I may get the name wrong, Mr. Satterbo, I think.
Yes, that's correct.
Okay. How does that inform our view of your argument that State Farm is could not be brought in when it appears that the stipulation that gets entered only between and only signed by State Farm's assigned counsel for Mr. Satterbo and plaintiff's counsel, but not Mr. Satterbo individually or even the separate lawyer that he had representing his interests individually, when that stipulation basically cuts him off at the feet and puts him into well in excess of liability of what the policy limit would be, which is the position that you're taking now. Does that inform our view of the argument that State Farm is trying to advance, which is that, look, we're only responsible up to policy limits. We can't be held responsible if we're not made a party to this, when the lawyer they hire is positively putting their client into liability for an amount well in excess of the policy limits. Do you understand my question?
I believe so, Your Honor. The negotiation of the fee amount may have resulted in a good deal for Mr. Satterbo. I don't know. That was that negotiation was handled by Mr. Satterbo's lawyer, which was hired and paid for by State Farm. I'm not sure I can get much further than that because he could not have negotiated something. He negotiated what he could negotiate, Your Honor. It saved money, it saved time, perhaps. I don't see the relevance of it as to adding State Farm to a judgment outside of the prescription.
Well, because it seems to indicate, to my mind at least, that State Farm is taking a position that puts the insured customer in a position whereby that insured customer is solely responsible, even though the insured customer hasn't signed off on that stipulation and State Farm has assumed that responsibility for him. And in fact, that insured customer, just so happens in this case, had separately retained counsel to represent his interests. It seems to be a positional conflict, and that's why I'm bringing it to your attention, because it seems to be in a conflict of the position that you're now bringing to us on this appeal.
The positional conflict would be between State Farm and Mr. Satterbo's lawyer and Mr. Satterbo. Mr. Satterbo was represented by Mr. Wood, who had sole allegiance to Mr. Satterbo, at least at that point. And I do not see how that becomes a positional conflict for State Farm. Your Honor.
Well, let me take your argument to the most logical extent, because now you're telling me Sid Crawford can't bind State Farm. Is that what you're saying?
State Farm. Your Honor.
Sid Crawford,
Yes.
retained by State Farm. He couldn't bind State Farm pre-trial when he received an offer within policy limits and a consent judgment and an assignment of a claim against the agent. And he said State Farm rejects, didn't even copy the Satterbos, didn't consult with the Satterbos, didn't tell the Satterbos they'd be personally liable in any way. He did that on behalf of State Farm. The letter says so. And then subsequently, the $1.5 million OJ, PFS, he said State Farm rejects that too.
State Farm had State Farm's policy limit, of course, was $300,000. It had no contractual obligation.
Oh, I'm aware of
more than
that.
its indemnity dollars.
I'm aware of that, and I'm aware of your novel
And no-
argument that a carrier is not responsible for an OJ that's over policy limits.
Yeah.
There is not one case that says that. Not one.
Right. And there is not one that gives a reasoned opinion that says it is.
Well, then you're asking us to ignore the law. Because the
I'm
law
asking-
says, don't interrupt me, sir. The law says a party offers a party, and the party's responsible. Well, based on your argument, State Farm can't be sued directly because of non-joinder. But State Farm controls the litigation against the Satterbos. $1.5 million OJ. Rejected. Law says you lose, you pay. Does not include anything about an insurance carrier, policy limits, nothing. But you're arguing that a carrier is not responsible if an OJ is over the policy limits and the defense loses or rejects it and loses.
It may be responsible, Your Honor, in a bad faith or declaratory judgment action.
Show me
Which
the
is-
law.
Pardon me?
Give me a case.
Well, a bad.
Macedo
well,
says
Sparks versus
nothing.
Barnes.
Macedo says
versus
nothing
Barnes.
about the OJ being within policy limits. That just happened to be the facts. That's not the holding.
Every case that I'm aware of, and I think we have cited several, including Sparks versus Barnes from this court, has said that it is when it is the timing of the determination of coverage. Now, it cannot be determined in an action where State Farm is not a party and so has no ability to defend itself. I'm making a coverage argument now, Judge, which sort of demonstrates the
Yeah,
problem.
but I don't understand your argument because the non-joinder statute says you can't be joined if you denied coverage. Well, State Farm never denied coverage until they were sued for bad faith.
You can be denied, you can be, I believe in it, I believe an insurer can be responsible for that fee liability, but not joined under the non-joinder statute. It is made liable for that fee liability in a separate declaratory or bad faith action. That's the
What you're really trying to argue is to go back in time and to require, basically to write out the non-joinder statute anytime that the insurer contends or later argues that it's not. But that's not what the statute says. The non-joinder statute cites to the claims administration statute, which requires, and this, you know, this is a point of great importance when an insurer issues a written denial or written reservation of rights. That is an important act that the insurer does, and there's a reason why that gets explicitly brought into the non-joinder statute. But that we don't have that in our record, do we?
You don't, for a reason, because of the case of AIU Insurance Company versus Block Marina Investments, where the Supreme Court, in very similar circumstances, in 1997, discussed what the term, quote, coverage defense, as used in the claims administration statute means. It means coverage that otherwise exists, but will not be provided because of some failure, like a failure of a condition preceding, a failure to cooperate, a failure of notice, something like that, where there is coverage, but we're not giving it to you. That's what the Florida Supreme Court said in 1997. It does not, the claims administration statute has no operation, quote, where the coverage sought is expressly excluded or otherwise unavailable. And it is otherwise unavailable. The AIU case has been cited 97 times when I looked at it.
Why is it unavailable here?
It's unavailable because our policy does not provide coverage for fee liability, and it cannot.
Actually, but it does. So you want us to undo Macedo, which basically cites very similar language as the policy that you have here, which your policy says, in addition to the limits of liability, it will cover costs and expenses. Which, look, right or wrong, better or worse, Macedo has interpreted that to include attorney's fees that arise in the course of a proposal for settlement. I mean, how do we do that without saying, I don't know, how do we distinguish Macedo from that? I mean, it's really what you're saying. You're saying there's no coverage here because this shouldn't fall under Macedo. I'm trying to figure out how that is.
Judge, we should not be arguing Macedo or coverage in this proceeding at all.
I knew you were going to go there, Mr. Russo, but here's the thing. The only way the only way we can construe the absence of a written denial or a written reservation of rights in the record as otherwise cutting you off at the feet is by virtue of the argument that you're making, which the argument that you're making is that this is not a covered, there's no coverage here, which in turn depends upon an interpretation of Macedo. So we can't be put in an analytical tautology. We can't go in that whipsaw. We have to deal with it because the lights of your argument necessarily take us to this point.
I respectfully disagree, Your Honor. This is without prejudice to raise these coverage arguments in the first instance in a separate action. We're not saying that we don't have coverage. I don't want to argue coverage here. I just want to say that the procedure by which we were added did not allow us to make our coverage argument. We should not be arguing coverage in the first instance, either in a motion, in a non-joinder motion, in the face of the terms of AIU Block Arena. We should not be arguing coverage in the context of an appeal where we don't have a trial court ruling on the coverage issue. This court should not be looking at coverage. We don't get the coverage. Coverage should be determined in another action, and there is another action. There's a declaratory judgment, bad faith action by Marguson and Satterbo and Hillsborough County. It is being litigated there. I will face the music. My client will face the music and make the arguments about Macedo and explain its provisions, but this forum is not the place for it. It wasn't the place, and the proceedings in front of Judge Durden were not the place for it. And Judge Durden, he heard the arguments, but he didn't listen to them. And the court is aware of the record, 4959, Judge Durden said, I hear what you're saying, State Farm, if that language was gratuitous or accidental, the and is insured language, well, the second DCA will have to tell me because I'm not going to do it.
So let's tackle that real quick. First of all, I'm not sure I agree with your premise that he didn't consider it because as I read he was into the substance of this. He may not have given you a ruling on the substance, but he saw what was coming. He saw your argument and he did raise some questions about it. How would this panel go about doing what it is you're asking us to do in light of the fact that a prior panel had in multiple instances already held State Farm to be liable for these fees, and relatedly, could State Farm have come in and sought relief in some way after that prior panel decision came out, given that its hired attorneys were aware of what was going on there?
Well, your second answer first. There's no intervention, as the court knows, in an appellate proceeding. There was no mechanism for us to contest that. Number two, the first question that you asked, what would you like it to do? What we're seeking is, number one, a reversal of the order that joined State Farm to the fee judgment without prejudice to Mr. Marcuson and Mr. Satterbo to bring their coverage action in another separate proceeding where for the first time in a trial court, we get to make our case. We have not had that opportunity. Now, we did get in front of Judge Durden, but Judge Durden said, I know what I have to do. I have to listen to the second, the prior panels and his insurer language. They will tell me if I'm wrong. Judge, that's why we're here. It's because we were not a party to that appeal.
I understand that. I understand that argument, Mr. Russell. Maybe I should have made my question a little bit more clear. It was, obviously you want us to reverse the order that's before us. I should have made clear. What do you want us to do with a prior panel decision that we are bound to?
Stick, Your Honor. Last week we filed a case, Supplemental Authority Epperson, and in that second DCA case, a panel of this court was presented with some precedent that one of the parties said was binding. And on review in footnote 9 of that Epperson case, there was a discussion about what was said about one of the parties there who was not an individual who was not a party to that case. And this court said, we construe that as dicta when an appellate court contends that it's adjudicating the rights and liabilities of an entity or a person who is not a party. That is dicta. And I think aside from being error or misapprehension or whatever, for purposes of this panel, you are not bound by that dicta because State Farm was not a party to 2D 14-27-37.
So, Mr. Russo, the case that you are citing in the footnote referenced a prior case where there's literally a single phrase that said this person could also be liable, and we then later said, hey, that was dicta. Here we have an order that says in multiple places, defendant and his insurer are liable. I'm not sure we can wedge that.
7 times it says it, Your Honor, and one of them is a plain. I'm sorry, I didn't mean to interrupt.
No. I'm just not sure how we wedge that into the silo of dicta.
Well, go back to the moving papers and the motion for review of Marcuson, and where there is coverage arguments, pages and pages of it, why State Farm's policy provides coverage for the fee liability that he's asking be imposed on Mr. Eric Satterthwaite. Is there a response? No, because State Farm was not a party to the action. And that's why this court, the prior panel, I should say, nobody ever raised the red flag. Hey, State Farm is not a party. You can't adjudicate its rights when it's not here. The Satterthwaite's lawyers.
Mr. Russo, I know you're trying to answer a question, but I've let you go over your 20 minutes.
Ooh.
And I'm going to give you, well, because you are answering questions. And that's fine. I'm going to also give you, it's your fault, Judge Lucas.
It is.
I'm going to also give you rebuttal time, but I am going to cut you off right now.
Yes,
and Mr. Caldavia, it's your turn. And, you know, to be fair, if you need more time, if you feel like you need more time, I'll let you. He went over 20 minutes by about a minute.
Thank you, Judge Kelly. Hopefully I won't go over the time. May it please the court, Your Honors, I'm Dave Caldavia. Here with me in my office in the background of the Zoom hearing is my co-counsel, Pat McNamara and Dan McBreen. We represent Mr. Marcuson. Just for clarity, I have conferred with the counsel for the other appellees, and they'll be relying on their answer brief and have allocated their oral argument time to me.
Okay, good.
Your Honors, as I think is already clear from what I've heard today, our position, State Farm's problem is not that it was denied due process. State Farm's problem is that it has no evidence to demonstrate that it ever complied with the non-joinder statute and no legal arguments to avoid joinder under that statute. And because of that, there is no amount of additional due process that will ever result in a different outcome in this case. According to the joinder statute, State Farm could only avoid joinder by 2 ways: by providing the insured defendant, that's Eric Satterthwaite, not my client, but Eric Satterthwaite, a timely written notice that they were either denying coverage or that they were defending under a reservation of rights. There's no evidence that that happened in this case. In fact, regardless of what happened in the prior appeal, in the trial court proceedings on remand from that appeal, our joinder motion argued the merits. We didn't just merely rely on this court's appellate decision against Eric and his insurer. Our motion also relied on the non-joinder statute, the policy language, and the controlling case law. And shortly before, we had a hearing scheduled on our joinder motion, and a couple of days before that hearing, we served them, properly noticed. Due process was complied with on notice. We get a memo from State Farm, from Mr. Russo's firm, and it says 3 times in it, oh, we denied coverage. We complied with the non-joinder statute. You can't get there because we denied coverage. Said it 3 times. We were shocked by this. So we canceled the hearing and we issued a subpoena to State Farm saying, if you've denied coverage, please send us these letters that are sent certified mail by the deadlines indicated by the non-joinder statute. What do we get back? It's in the record. We got a lot of objections and nothing, no documents. Why? Because there is no document. Because State Farm, when they got our offer of judgment, our proposals for settlement. They didn't turn to the insured and say, wait, hold everything. We're going to defend on a reservation of rights. This additional payments provision that we have in our policy, we're not paying any attorney's fees. We're reserving our rights under that. They didn't do that. They didn't deny coverage. They went forward. They took control of the case. We went forward. After we subpoenaed them, we went forward with the hearing. And that was a properly noticed hearing. At that hearing, first of all, State Farm's memo was like 20-something pages long. They argued the merits too. They went full bore on everything. They argued due process. They argued that the non-joinder statute didn't apply. They argued that their policy doesn't apply. They argued everything they could possibly argue, except for the fact that we sent them the notice. That's nowhere to be seen anywhere. So we go to that hearing, and Judge Lucas, I know you read the transcript. That hearing transcript shows that both sides fully argued the merits under the non-joinder statute, the policy language, the case law. And Judge Durden fully participated in that hearing. He wasn't just sitting there watching his clock. He was quizzing both parties about this. And during the hearing, you'll find there's 5 pages of colloquy between Judge Durden and Scott Damon, who's Mr. Russo's partner who represented State Farm in this case, and I'll get to it in a minute. I want to read the transcript to you, but the bottom line of that 5-page colloquy, and it's at the record 4948 through 4951, 5 pages of colloquy where Scott Damon essentially admits that even when the plaintiff sends an offer that exceeds the policy limits, the insurance company is in control of the settlement and in control of the defense after that. I'm going to read that to you when we get there in a minute. Mr. Damon, at that same hearing, also under quizzing by Judge Durden, admitted that State Farm's policy language, under that policy language, State Farm, and I'm going to quote, would be on the hook under Macedo, plain as day. That's Mr. Damon's statement to the court, page 4954 of the record. So the policy language is decided. It's been decided time and time again. It covers attorney's fees in this situation. Now, on the due process end, Judge Durden's decision at the end of the day was, okay, well, there's a second DCA decision and I'm going to go ahead and comply with that. But State Farm didn't step up and say, well, wait a minute, we want you to make some findings of fact here, Judge. We want you to make some findings of fact that that we complied with the non-joinder statute and that, you're bound by the second DCA's decision. But if you weren't, that you'd be ruling in favor of State Farm. You'd make these findings of fact. We'd appreciate that. They never asked for that. And if you look at the New Hampshire versus Gray decision, that's the same situation. In that case, the court said, well, insurance company, you're complaining that there's no findings here no findings of fact, but you didn't ask for any. So what's going to happen? What more due process does State Farm get? It's going to result in it's an exercise in futility, because the undisputed facts demonstrate as a matter of law that they never complied with the non-joinder statute and that State Farm's in control of the defense. And so that's what this case really boils down to. The trial court already afforded State Farm due process, but to be clear, State Farm has no evidence to defeat our joinder motion. Without going en banc, we respectfully maintain this panel is not authorized to reverse Judge Morris's, Judge Silberman, and Judge Slayer's previous decision. But even if this court, or even an en banc court, reversed and awarded State Farm some more due process with another hearing before Judge Durden, the same result would have to be reached, because the undisputed evidence is and always will be that State Farm did not provide written notice under the joinder statute. So, you can look at it maybe under a tipsy coachman approach. Everything's been argued. Yes, Judge Durden's oral ruling was that he was going to follow the DCA's decision, but his order is that he reviewed everything and our motion was granted. As far as the PFS, the fact that our proposal exceeded the policy limits. State Farm argues, and Judge Sleet said, well, there's no case that says that that is a factor. And Mr. Russo says, well, there's no case that's going the other way. Well, there is another case going the other way. The Davis versus Miro case out of the 4th BCA is this exact same situation. The proposal for settlement exceeded the policy limits, and the insurance company rejected that proposal, just like State Farm rejected the proposal for settlement. In this case, State Farm did not offer to participate in that settlement. They could have just tendered their policy limits, right? They could have just stroked a check and said, we're out of this now as far as our policies, and we'll continue to.
Well, Mr. Calvia, let me take that to task for just a minute, because the Macedo opinion does have a part that didn't get really hit upon by Mr. Russo, but it does say, because Geico was authorized to settle the case and could have settled in this case for half of the policy limit, it did not have to ask Lombardo to accept or reject settlement offers. A very strained reading of that, or a stretched reading, I should say, could be along the line that, look, since you don't have to cooperate with your insured to accept the offer of judgment because the accepting it would still be within your policy limits, therefore we're going to interpret the policy of working with them to be that you did have complete control. Take the ancillary is that, well, if the offer exceeds it, now you got to do some kind. You have to have a talk, if you will, with your insured. And this is a point that Judge Durden actually kind of touched upon during the hearing, which is mechanically, how would this work? How would it work, even on the light of your own argument, Mr. Caldevillo, which is that, well, at that point, you just tender policy limits. Well, except tendering policy limit would not be an acceptance of the offer of judgment.
Okay.
Right?
All right.
So they're still on the hook.
State Farm wouldn't be on the hook. I mean, State Farm could have settled this case. Some insurance companies, when there's an insurance claim, they go ahead and pay policy limits before you even have to sue them.
Right.
That happens. Right. Okay.
Yeah,
you don't have to settle release when that happens.
And I knew that was where you were going to go, which is tender the policy limit before we go to trial and everything's fine. But my point is, look, you're at a point now where you've litigated. You've now got an offer of judgment on the table. It exceeds policy limits, right?
And those were the facts of Macedo. Those, as Judge Sleet, those were the facts. But those facts did not control the holding. The holding is, it's because the insurance company controls the defense and controls the settlement is why they're on the hook for the attorney's fees under this provision that they agreed to pay the insured's legal costs.
Your reading of Macedo is that it turns on the degree of control that the insurance company has over the entire settlement process, regardless. I mean, in theory, there's nothing written in stone that says an insurance company can't settle above its policy limits. They could if they're worried about a future bad faith claim. Your reading of Macedo is that the holding turns on control, and the same control that was present in Macedo is present here.
Yes, and if you read and I know you probably have this Davis versus Muro, which we cited in our answer brief, it's a situation. But what's interesting, and we just discovered it yesterday and going through, shepherdizing at the last minute. But after we filed our answer brief, we learned that Nationwide took an appeal of the Davis versus Muro decision to the Supreme Court and said, hey, this conflicts with Macedo. And the Supreme Court denied review on that. Now, it's just a denied review. But they also awarded attorney's fees. So I cited that in a supplemental authority late yesterday. I don't know if your honors got to see that, and I apologize for the lateness of that. But that's the issue, is control. And if you, Judge Lucas, I mentioned before that in the transcript, and you've already hit on it, but 5 pages of colloquy, Judge Durden's asking Mr. Damon, well, show me how this works. If the plaintiff offers more than to settle and that exceeds the policy limits, how does that work? And he goes round and round. Well, that doesn't answer my question. That doesn't answer my question. Yeah. So it gets to the end of that 5-page colloquy on page 4944 of the record. Judge Durden asks, if the demand is more than the policy limits, does the insured themselves at that point that you're in excess of the policy limits get to call the shots? Or is it the insurance company still calling the shots? Mr. Damon says, fundamentally, as the courts know, policies are written such that, because it's the money of the insurer at stake, they control the litigation. And then Judge Durden makes sure he's got it right. He says, okay, recapping here, he says, a demand is made for more than the policy limits. It's the insurance company that decides whether to accept that or not, or go to trial, right? Mr. Damon's answer, absolutely yes. That's page 4950 of the record of that transcript. So, state, and on top of that, and stop with Mr. Damon's acknowledgement of the obvious, the policy itself says that that the insured has to cooperate with State Farm on whether they want to settle or not, and that they have the right to settle. So the insured can only settle if State Farm wants to settle. And State Farm told Sid Crawford that they didn't want to settle. They sent him a letter, and Sid Crawford then sent that letter that's in the record to the Satterbo's private counsel, Mr. Valenti, saying, talk to State Farm. They're having no part of either of these settlement offers. So the record is undisputed. State Farm was the one who rejected the Mr. Markinson's offer. State Farm never said, as far as we know, and they could have presented evidence of this at the hearing we had. There was no request to present any more evidence, to adjourn, to provide more, nothing like that. From what we know, State Farm did not say it was going to contribute its policy limits towards that settlement. Hey, Satterbo's, if you want to accept this offer of judgment, have at it. We'll kick in $300,000. Or we'll just go ahead and stroke a check for $300,000 and we'll continue to defend you. They didn't say that. They didn't want to settle. They didn't settle. They kept driving up our attorney's fees. They've appealed how many times? Look at your record. I think this is the 4th appeal now that we have in this litigation. Some 15 years after the accident that severely injured Mr. Markison. Let me just check my notes here. There were a couple of things that came up. Mr. Russo said that Mr. Wood, that he had sole allegiance to the Satterbo's. His allegiance was solely to the Satterbo's. But when we went before Judge Durden, Mr. Wood said, "Oh, I got nothing to say here. My lips are sealed." He said nothing. He could have said, I agree with Mr. Caldevilla. My clients should not be responsible for these attorney's fees. I think State Farm should be joined to the judgment and they should be jointly and severally liable. Not a word from Mr. Wood. Who controlled Mr. Wood? If he was truly had sole allegiance to the Satterbo's, don't you think he would have said something at that hearing? Never said it. Never said a word, except to say that he wasn't going to participate. Mr. Russo also said that State Farm could not intervene. I beg to differ. There is case law. There's no rule of Florida appellate procedure that allows intervention, but there is case law in Florida and case law abroad where parties to an appeal actually do intervene, or non-parties actually do intervene. Is it rare? Yes. But in this case, it wasn't required. State Farm had knowledge of everything. They were privy. They were in privy to the Satterbo's, and that's why the case law says that res judicata, collateral estoppel, law of the case, those doctrines apply to parties and their privies. So they weren't deprived due process by this court, but even if there was a mistake, a due process mistake by this court, which I disagree with, but even if there was, they got plenty of due process before Judge Durden. He heard everything and he rejected their arguments, rightly so. Why? Because they had no evidence. They got no evidence to support their position. And for those reasons, we request this court to affirm. And I thank you for your time.
Thank you. All right, Mr. Russo.
Thank you, Judge. Number one, State Farm received 0 due process in front of the first panel, 0, where the entitlement order was entered which was Judge Durden found to be binding on him. Number two, refer the court to record 4709, where State Farm did deny coverage in the Hillsborough County action where the coverage is disputed. So there was a communication, perhaps not in the form of the claims administration statute. But Judge Lucas, I want to impress upon you the importance of AIU versus Block Marina, that case which is 30 years old and construed a statute which the legislature has known about for 30 years and never disturbed, and has nearly 100 cases citing to it in one form or the other, where an insurer, a liability insurer, is not joined to a judgment if there is a contest of coverage. And it did get it did alter the way the claims administration statute is enforced and how the non-joinder statute works. We should never be talking about coverage at this point. We should not be talking about Macedo. We should not be talking about control of the litigation. Mr. Caldevilla just gave his closing argument for the bad faith case that's going to trial next summer, but that shouldn't be here. What's at issue here is whether Judge Durden properly applied the correct law in joining State Farm to the judgment. He felt he had no choice but to obey and his insurer language, which is dicta from the prior panel. And they could have said it 100 times, but that doesn't mean State Farm obtained due process by the prior panel. We were not a party. We could not have had due process. That trumps everything. And that's where I wanted to start and stop and not let the court go down the rabbit hole of what does Macedo say, what does Muro say. And by the way, Muro, if you read, and I'll provide the court with the trial courts, with Nationwide's trial presentation in opposition to joinder, which is an appellate lawyer's nightmare because they didn't preserve anything. I'll present the court with a brief, which is available to the public, which is excellent, well written, and I will ask the court to read the Muro opinion with those two pieces in mind. The supplemental authority is something that's come up today. But I think what we're asking the court to do is to reverse the joinder of State Farm to the judgment and let the lower tribunal know that the and his insurer language is not binding because there is another action. I mean, of course, this action will know, but there is another court in Hillsborough County that will look at all these issues, and they are going to look at what happens here, and they are looking at the and his insurer language. But AIU Block Marina judge does not require compliance with.
I just want to be clear, Mr. Russo, that you would, based upon that final part, you would object if this court were to reverse and remand solely for the purpose of to have Judge Durden make a ruling on the merits of the motion as opposed to saying he was bound by the prior panel decision. You would object to that.
The merits of the motion to join, Your Honor?
Yeah, because that was one of the things they asked for.
No, I would not object. That would be better than an affirmance. Yes, sir.
Okay.
Just for the record, AIU filed an ROR, Mr. Rose.
I'm sorry, Your Honor?
AIU filed an ROR in that case. You didn't.
Okay, thank you both. Mr. Caldevilla, I know you have some objection to something Mr. Russo was proposing. If he files something, you certainly can file a response.
Thank you, Your Honor.
Okay, thank you both. That concludes the argument, and that concludes our docket for today. Thank you, everyone.